The white SUV tore through my wheat field at 7:30 a.m. on a Tuesday, mud spraying and thick arcs behind the tires. I had owned this land for 6 years, long enough to know every fence post, every boundary marker, every inch of soil that belonged to me. And now, for the third time this week, someone had decided my property was just a convenient shortcut. The wooden fence post snapped like a twig under the weight of the vehicle. The driver did not slow down, did not glance back, just kept going as if my stewardship meant nothing. I set my coffee on the gate, feeling the warmth bleed through the ceramic into my palm, and walked toward the tire tracks. My chest tightened with each step, not from anger yet, but from something quieter and more dangerous. What happened next taught me that boundaries are not suggestions. They are lines you defend, or they disappear. And if you are watching this, please comment below with your location, because this lesson has cost me more than I expected. I bought the land in 2018, back when the county road still felt like the edge of the world. 12 acres of open farmland, flat and quiet, with wheat that turned gold every summer, and a sky so wide you could see weather coming from miles away. The property sat outside the new housing development being built across the road, separated by asphalt and a stretch of empty grass that nobody seemed to own. The realtor told me it was a good deal because the land had no HOA restrictions, no covenants, no one telling me what I could or could not do. I signed the papers the same day. The first thing I did was fix the old wooden gate at the front of the property. It was weathered gray, the kind of wood that had spent decades soaking up rain and sun, but it was solid. I replaced the hinges, tightened the posts, and hung a metal sign on the crossbeam. Private property, no trespassing. The letters were black on white, clear enough to read from the road. I stood back and looked at it that afternoon, feeling something settle deep in my chest. This was mine. The rhythm of the land became my rhythm. I woke with the sun, walked the property every morning with coffee in hand, checked the wheat for pests, and fed the chickens behind the house. The work was simple, repetitive, and exactly what I needed after years of apartment living where the walls were thin and the world was loud. Out here, the only sounds were the wind through the stalks and the occasional truck on the county road. I had built this life carefully, and the sign on that gate was not decoration. It was a declaration. By late spring of this year, the housing development across the road was nearly finished. Frames went up fast, then siding, then driveways. Families moved in, and suddenly there were SUVs and minivans where there used to be dirt lots. I watched from my porch as the neighborhood took shape, rows of identical houses with mailboxes lined up like soldiers. It did not bother me. They stayed on their side. I stayed on mine. The county road between us was a clear division. Then, one morning in early June, I found the first tire tracks. They cut diagonally across the northwest corner of my wheat field, 2 deep ruts that started near the road and ended at the far fence. Someone had driven straight through instead of following the curve of the county road. I stood at the edge, hands in my pockets, staring at the flattened stalks. It could have been a mistake. Maybe someone took a wrong turn in the dark, panicked, and cut across to get back on course. I walked back and hammered a fallen post into place, telling myself it was a one-time thing. 3 days later, it happened again. Same path. Fresh mud sprayed across the young wheat. This time, I bought 2 more no trespassing signs and posted them at both corners facing the road. I made sure they were visible, reflective, and impossible to miss. When I hammered the last one into the ground, I felt a flicker of satisfaction. Now, nobody could claim they did not know. But on Tuesday morning, I was standing at the gate with my coffee when I heard the engine. It was loud, aggressive, the kind of sound that comes from someone driving too fast. I turned just in time to see the white SUV veer off the county road and plow straight through my field. Mud sprayed. The wooden post I had just repaired snapped in half. The vehicle did not slow down. It carved a fresh path through the wheat and disappeared around the bend, taillights flashing once before vanishing completely. I set my coffee down, hands shaking, and walked toward the new tire tracks. They were wider this time, deeper, like the driver had accelerated on purpose. I crouched and touched the torn earth, feeling the dampness between my fingers. My chest felt tight, not with rage, but with something colder. This was not an accident. This was a choice. Someone had decided that my sign, my land, my 6 years of careful work meant nothing. I stood slowly, wiping my hands on my jeans, and looked back at the road. The white SUV was gone, but I knew it would come back. People like that always came back. I spent the rest of the morning checking every post, every corner, making sure nothing else had been damaged. The land was still mine. The deed was still filed at the county office. But standing there in the quiet, with the sun climbing higher and the wheat rustling in the breeze, I realized something had shifted. That gate was no longer just wood and metal. It was a line I would have to defend, and I was about to find out whether I had the spine to do it. The white SUV came back on Thursday. I was inside the house when I heard the engine reverend, that same aggressive growl that made my jaw clench. I walked to the window and watched it cut across the field again, this time even closer to the wheat I had planted in April. The tires churned through the soil, spraying dirt in wild arcs, and the vehicle did not hesitate. It moved like it owned the place, like my signs were suggestions instead of warnings. I stood there with my hand pressed flat against the glass, watching until the SUV disappeared past the tree line on the eastern edge of my property. My heart was pounding, but I did not move. Not yet. I waited until the dust settled, then walked outside. The new tracks carved a jagged line through the center of the field. Stalks bent and shredded where the tires had torn through them. I ran my hand over the damaged plants, feeling the rough edges. This was not carelessness. This was contempt. I decided I needed to see the driver face to face. If this were just a misunderstanding, I could clear it up with a conversation. If it was something else, I needed to know. So on Friday afternoon, I parked my truck at the edge of the property near the county road and waited. The sun was high, the air thick with heat, and I sat there for 2 hours with the windows down, watching every car that passed. Most of them were sedans or pickups, people heading into town or coming back from work. But just after 3 p.m., I saw it, the white SUV, coming from the direction of the housing development, slowed as it approached my land. I got out of the truck and walked to the middle of the road, raising one hand to signal the driver to stop. The SUV slowed, then came to a halt about 10 feet in front of me. The engine idled, low and steady. For a moment, nothing happened. Then the driver's side door opened, and a woman stepped out. She was in her late 40s, maybe early 50s, wearing a charcoal blazer and dark jeans, her hair pulled back in a tight ponytail. She had sunglasses on, the kind with large frames that covered half her face, and she was carrying a clipboard. She looked at me like I was an inconvenience, like I had interrupted something important. I kept my voice calm. "Ma'am," I said, "you have been driving through my property. This is private land." She tilted her head slightly, her expression unreadable behind the sunglasses. She did not apologize. She did not ask questions. She just looked past me toward the field, then back at me, and said, "This is a community access road." I blinked, not sure I had heard her correctly. I said, "No, ma'am, this is my land. I own it. It is not part of any community." She let out a short breath, almost a sigh, and adjusted the clipboard under her arm. "You are blocking a shortcut that residents use," she said flatly. "We will take this up with the homeowners association." I felt my hands curl into fists at my sides, but I kept my tone level. "There is no homeowners association here," I said. "This land is not part of your development." She looked at me for a long moment, then shook her head slowly, like I were a child who did not understand basic rules. "We will see about that," she said. Then she turned, climbed back into the SUV, and slammed the door. The engine roared, and she pulled around me, tires kicking up gravel as she accelerated back toward the housing development. I stood in the middle of the road, watching her taillights disappear, my pulse hammering in my ears. That night, I could not sleep. I sat at the kitchen table with every document I had related to the property spread out in front of me. The deed, the survey map, the title insurance, and the county records. I went through each page slowly, tracing the property lines with my finger, double-checking the legal description. Parcel 47B, 12.3 acres. Purchased in 2018. Recorded at the county recorder's office. No easements, no shared access, no mention of any homeowners association. The land was mine, free and clear. But the woman's words kept looping in my head. Community access road, homeowners association. She had said it with such certainty, like she had the authority to rewrite reality. I leaned back in my chair and stared at the ceiling. Either she was wildly misinformed, or she was lying. And if she was lying, that meant this was not just about a shortcut. It was about control. The next morning, I walked the property again, this time with my phone in hand, taking pictures of every tire track, every broken post, every section of damage. I documented everything methodically, noting the dates and times as best I could remember. I did not know what I was going to do with the photos yet, but I knew I needed evidence. If this escalated, if it turned into something legal, I wanted a record. By Sunday, the white SUV had come through twice more, once in the early morning, before I was awake, and once in the late afternoon while I was feeding the chickens. The second time, I heard it coming and ran toward the road. But by the time I got there, the vehicle was already gone. All that remained were fresh ruts and the faint smell of exhaust hanging in the air. I stood at the edge of the field, hands on my hips, breathing hard. My ribs felt like they were laced too tightly, pressure building with every breath. But now it was mixed with something sharper. Frustration, helplessness, the feeling that no matter what I did, this person would keep tearing through my land like it was nothing. I went back inside and sat at the table, staring at the pile of documents. The deed was right there, black ink on white paper, legal and binding. But that woman did not care about paperwork or property rights, or the 6 years I had spent building this life. She cared about her shortcut, and she was willing to drive over everything I had to get it. I closed my eyes and took a slow breath, trying to calm the anger building in my chest. This was not over, not by a long shot. The letter arrived on Wednesday, slipped into my mailbox like a piece of junk mail. I almost threw it away without reading it. The envelope was plain white, no return address, just a printed label with my name and property address. I opened it standing at the end of my driveway, pulling out a single sheet of paper folded in thirds. The letterhead at the top read, Meadowbrook Homeowners Association, in bold letters, with an address that matched the housing development across the road. I scanned the text, then read it again, slower this time, making sure I understood what I was seeing. The letter stated that my property was located within the boundaries of the Meadowbrook community and was therefore subject to the rules and regulations of the Homeowners Association. It claimed that I had been blocking a designated community access route and that I was required to either grant easement access or face potential legal action. The letter demanded that I contact the HOA board within 10 business days to resolve the matter. It was signed by the board president. No name, just a title and a printed signature line. I stood there for a long time, staring at the paper, feeling my stomach twist into a knot. This was insane. I had bought the property 2 years before the development even broke ground. The county records were clear, but here was a letter, printed on official-looking stationery, telling me otherwise. I folded it carefully and walked back to the house, my mind already racing through what I needed to do next. I spent the rest of the day on the phone. First, I called the county recorder's office and asked them to confirm the legal boundaries of my property. The clerk was patient, walking me through the parcel map on their website, pointing out that Parcel 47 was clearly outside the subdivision plat for Meadowbrook. She emailed me a copy of the official map with my parcel highlighted in yellow. It was right there, separated from the HOA by the county road, with no overlap, no shared boundary, nothing. I printed the email and added it to my growing stack of documents. Next, I called the county assessor's office and asked if there were any easements or restrictions tied to my property. The woman on the phone pulled up my file and confirmed that there were none. No easements, no covenants, no homeowners association dues. My property was classified as agricultural, zoned for private use, and had been since it was first surveyed in 1976. She asked if I needed a certified copy of the records. I said yes. She told me it would take 3 business days. I hung up and sat at the kitchen table, staring at the HOA letter. Everything I had just confirmed contradicted what this letter claimed. But the letter existed. It was real. Someone had typed it, printed it, and mailed it to me. And that someone was either dangerously misinformed or deliberately lying. I picked up my phone and dialed the number listed at the bottom of the letter. It rang 4 times before someone answered. A woman's voice. Professional. Clipped. Meadowbrook Homeowners Association. How can I help you? I recognized the tone immediately. It was the same woman from the SUV. I kept my voice steady. This is Alden Pierce, I said. I received a letter from your office claiming that my property is part of your association. It is not. There has been a mistake. There was a pause, then a short laugh. More exhale than humor. Mr. Pierce, she said, we have reviewed the community boundaries and your property falls within our jurisdiction. You will need to comply with our access requirements. I said, I have the county records in front of me. My land was purchased before your subdivision was even platted. She interrupted me, her voice sharpening. Our legal team has already reviewed this matter, she said. If you refuse to cooperate, we will pursue a lien against your property. I suggest you reconsider your position. I sat there, phone pressed to my ear, trying to process what I had just heard. A lien. She was threatening to put a lien on my property for refusing to let her drive across it. I opened my mouth to respond, but she had already hung up. The line went dead. I set the phone down slowly, staring at it like it might explode. My hands were shaking, not from fear, but from the sheer audacity of what had just happened. This woman had just threatened me with legal action over land she had no claim to, and she had done it with the kind of confidence that suggested she thought she would win. That evening, I drove into town and parked outside the Meadowbrook development. I wanted to see what I was dealing with. The entrance was marked by a stone sign with the community name carved into it, flanked by landscaped flower beds and a row of young trees. Beyond the sign, the streets were wide and clean, lined with identical 2-story houses in shades of beige and gray. There were SUVs in every driveway, basketball hoops over garage doors, kids riding bikes in tight circles. It looked peaceful, normal, the kind of place where people moved to feel safe and comfortable. But somewhere in that maze of cul-de-sacs and manicured lawns, there was a woman who thought she could take my land just because it was convenient. I sat in my truck for a while, watching the neighborhood settle into the evening. The lights came on in the windows, garage doors closed. A man walked his dog past my truck, waving politely. I waved back. These people probably had no idea that their HOA president was using their name to justify trespassing. But that did not change the fact that I was now in a fight with the system that claimed to represent them. When I got home, I sat down and drafted a response letter. I kept it short, factual, and firm. I stated that my property was not part of the Meadowbrook Homeowners Association, that I had county records to prove it, and that any further trespassing would be reported to the sheriff's office. I included copies of the county parcel map and the assessor's confirmation. I printed 3 copies, one for the HOA, one for my records, and one that I planned to send via certified mail so there would be proof of delivery. I signed my name at the bottom, folded the letter into an envelope, and set it on the table. Tomorrow, I will mail it. And then I would see what happened next. But as I turned off the lights and headed to bed, I could not shake the feeling that this was only the beginning. The woman on the phone had not sounded like someone who would back down. She sounded like someone who was used to getting her way, who believed that rules applied to everyone except her. And that terrified me more than anything else. Because if she was willing to lie about jurisdiction, what else was she willing to do? I mailed the letter on Thursday morning. The post office clerk stamped it, handed me the certified mail receipt, and I walked out feeling like I had drawn a line in the sand. But by the time I got home, that feeling had faded. A letter was not going to stop someone who had already threatened a lien. If I wanted to protect my land, I needed more than paperwork. I needed to understand exactly what I was up against. I sat down at my desk and opened my laptop. For the next 3 hours, I did nothing but research. I started with HOA law in my state, reading through statutes and case summaries until my eyes burned. The rules were clear. A homeowners association could only enforce regulations on properties that had voluntarily joined the association or were included in the original subdivision plat. My property met neither condition. I had never signed an HOA agreement. My deed predated the subdivision by 2 years. There was no legal mechanism for Meadowbrook to claim jurisdiction over my land. I cross-referenced my parcel survey with the Meadowbrook subdivision plat, both publicly available through the county planning office. My land sat on the north side of the county road. Meadowbrook was entirely on the south side. There was no overlap, no ambiguity. It was black and white. Next, I looked up the legal definition of trespassing in my state. Entering or remaining on private property without permission was a misdemeanor. If the trespasser caused damage, the offense could escalate to criminal mischief, which carries fines up to $1,000. I took notes, copying down the statute numbers, the definitions, and the penalties. This was not just about defending my land anymore. This was about building a case. I searched for information on HOA overreach and found more than I expected. There were forums, legal blogs, and news articles about homeowners associations trying to extend their authority beyond their legal boundaries. Some had succeeded through intimidation, others had been stopped, but only after long legal battles. I read through the stories, looking for patterns. One thing became clear. Documentation was everything. Photos, timestamps, written correspondence, official records. If I were going to prove that Meadowbrook had no authority, I needed evidence that could not be disputed. And for the first time since this started, I felt like I had a strategy. The next step was obvious. I needed to catch them in the act. The white SUV had been coming through my property for weeks, but I had no proof that tied the vehicle directly to the HOA president. In a legal dispute, my word would not be enough. I needed a video. I needed timestamps. I needed something that could not be dismissed. I went into town that afternoon and bought 2 trail cameras, the kind hunters use to monitor game trails. Small, weatherproof, with motion sensors and infrared night vision. The clerk at the sporting goods store showed me how to set them up, how to adjust the sensitivity, and how to lock them with cables. When I got home, I mounted one camera on a fence post near the main tire tracks, angled to capture anyone driving through. The second one I placed near the gate, pointed at the road, recording vehicles entering and leaving my property. I tested both cameras, walking in front of them to trigger the sensors. The red lights blinked. The footage was clear. That night, I sat at the kitchen table and created a spreadsheet. I labeled the columns date, time, vehicle description, location, damage, and notes. I went back through my phone and entered every incident I could remember, starting with the first tire tracks in early June. I did not have exact times for most of them, but I estimated as best I could. For the more recent ones, I added the photos I had taken. The spreadsheet turned weeks of frustration into something concrete, something I could point to and say, "This happened, and here is the proof." I also drafted an email to the county sheriff's office. I did not send it yet. I just wanted to have it ready. In the email, I explained the situation briefly. I stated that my property was being repeatedly trespassed upon by a vehicle associated with the Meadowbrook Homeowners Association. I noted that I had asked the driver to stop and had sent a formal letter to the HOA, but the behavior had continued. I explained that I was documenting the incidents and would be happy to provide evidence if the sheriff's office wanted to open an investigation. I kept the tone respectful, factual. I saved the draft and closed my laptop. The next morning, I walked the property one final time with a measuring tape and a notebook, documenting every section of damaged wheat, every broken fence post, every tire rut in a single sweep. I measured the width of the tracks, the depth of the intrusion, and the distance from the road to the farthest point of damage. I took photos with a ruler in the frame for scale. It felt meticulous, almost absurd, but it also felt necessary. I was not reacting anymore. I was planning. By the end of the week, I had everything organized. The spreadsheet was updated. The cameras were recording. The county documents were printed and filed. My letter to the HOA had been delivered, signed for by someone at their office. I had done everything I could think of to prepare. Now, all I could do was wait. Wait for the next violation. Wait for the HOA to respond. Wait for the moment when all this preparation would either pay off or prove useless. I sat on my porch that evening, watching the sun set over the wheat field, and felt a strange kind of calm. Whatever came next, I would be ready. The cameras caught her on Monday morning. I was in the kitchen making coffee when my phone buzzed with a motion alert from the trail camera app. I opened it and watched the video in real time. 7:42 a.m. The white SUV appeared at the edge of the frame, slowing as it approached my gate, then veering sharply to the left and cutting straight across the field. The tires threw mud in wide arcs. The vehicle bounced over the uneven ground, passed directly in front of the camera, and disappeared toward the far fence line. The whole thing took 11 seconds. I replayed it 3 times, making sure the timestamp was visible, making sure the license plate was clear. Every detail was there. I downloaded the footage immediately and saved it to 3 separate locations: my laptop, an external hard drive, and a cloud storage account. I added the video file to my spreadsheet, logging the date, time, and a brief description. This was the proof I needed. Over the next 4 days, the cameras recorded 6 more incidents. The white SUV came through twice more. A silver sedan appeared once, hesitant and slow. A black pickup truck tore through on Wednesday afternoon, leaving ruts so deep I could see them from my porch. I logged each one, backed up the files, and watched the evidence pile up. With every new video, the anger in my chest hardened into something colder and more useful: resolve. On Thursday, I received a response from the HOA. It was not a letter this time. It was an email, sent from an address listed as president@meadowbrookhoa.com. The message was short, formal, and dismissive. It stated that the HOA board had reviewed my correspondence and determined that my claims were without merit. It repeated the assertion that my property fell within community boundaries and that I was legally obligated to provide access. It ended with a warning: continued obstruction of community access may result in further action, including but not limited to the filing of a lien and the pursuit of legal remedies. The email was signed by Fiona Harcourt, President, Meadowbrook HOA Board. I read it twice, then printed it and added it to my file. Fiona Harcourt. Now I had a name. I also had a written threat, documented and time-stamped, from someone claiming authority she did not have. I forwarded the email to my personal archive and considered my options. I could respond. I could argue. I could try to reason with her. But I already knew how that would go. She did not care about facts or county records or property law. She cared about control, and she was betting that I would back down rather than fight. I was not going to back down. That afternoon, I drove to a hardware store 30 minutes outside of town and bought materials for a gate. Not a wooden gate this time, a metal one, steel frame, reinforced hinges, automatic opener with a keypad and remote control. The kind of gate you saw at private driveways in gated communities. It was expensive, more than I had planned to spend. But I was done with wooden posts that could be knocked over and signs that could be ignored. I spent Friday and Saturday installing it. The work was hard, physical, the kind of labor that made my back ache and my hands blister. I dug post holes 4 feet deep, mixed concrete, set the frame, and leveled everything twice to make sure it was solid. I wired the automatic opener to a solar panel so it would not need external power. I programmed the keypad with a code only I knew. When I finally closed the gate for the first time and heard the lock click into place, I stood there for a long moment, hands on my hips, breathing hard. It was done. I mounted a third camera on the gate itself, angled to capture anyone who approached it. I also installed a small metal sign next to the keypad: private property, no trespassing, violators will be prosecuted. The letters were larger this time, impossible to miss. On Sunday evening, I sat down and finalized the email to the sheriff's office. I attached the 7 video files from the trail cameras, each one labeled with the date and time. I included a summary of the incidents, a copy of the HOA's threatening email, and a PDF of my property deed with the county parcel map highlighted. I explained that I had tried to resolve the matter directly with the HOA, but they had refused to acknowledge the legal boundaries of my property. I noted that the trespassing had caused measurable damage to my crops and infrastructure. I requested that a deputy visit the property to review the evidence and advise me on the next steps. I read the email 3 times, checking for tone, making sure I sounded calm and reasonable. Then I hit send. The response came faster than I expected. Monday morning. My phone rang. The caller ID said County Sheriff's Office. I answered. A deputy introduced himself, said he had received my email and reviewed the footage. He asked if I was available for a site visit that afternoon. I said yes. He told me he would be there at 2 p.m. and asked me to have all my documentation ready. I said I would. When I hung up, I felt my pulse quicken. This was it. This was the moment when everything I had prepared would either matter or fall apart. I spent the rest of the morning organizing my files. I printed fresh copies of the deed, the parcel map, the HOA letters, and the email from Fiona Harcourt. I loaded the video files onto a USB drive. I made sure the cameras were still recording. I walked the property one more time, checking the gate, the fence line, and the areas of damage. At 1:50 p.m., I stood at the gate and waited. The air was still, the sky clear. I could hear my own breathing. And then, at exactly 2 p.m., I saw the patrol car coming down the county road, slow and deliberate, the kind of arrival that meant business. I opened the gate and waved the deputy through. It was time to make my case. The deputy's name was Martinez. He was in his mid-30s, calm and professional, with the kind of steady demeanor that made you feel like he had seen worse situations than this. He parked his patrol car just inside the gate and stepped out, adjusting his belt as he looked around the property. I walked over and shook his hand. He nodded toward the new steel gate behind us. "That is new," he said. I nodded. "Installed it this weekend," I said. "Got tired of people driving through like they owned the place." He looked at the gate for a moment longer, then turned back to me. "Why don't you show me what we are dealing with?" I walked him through the property, starting at the main tire tracks that cut across the wheat field. He crouched down, running his hand along the edge of one of the deeper ruts, then stood and took photos with his phone. I showed him the broken fence posts, the flattened crops, the sections where the soil had been churned into mud. He listened as I explained the timeline, starting with the first incident in June and working my way forward. He asked questions. "How many times has this happened? Have you spoken to the driver? Did you document everything?" I answered each one, keeping my tone factual, not emotional. "Yes, at least 12 times. Yes, I confronted her. Yes, I have video evidence." We walked back to the house, and I handed him the USB drive with all the footage. He plugged it into his laptop in the patrol car and watched the videos one by one, his facial expressionless. When he finished, he looked up at me. "This is pretty clear-cut," he said. "You have got trespassing, property damage, and repeat offenses. The vehicle is identifiable. Do you know who owns it?" I pulled out the printed email from Fiona Harcourt and handed it to him. "This is the president of the HOA," I said. "She is the one driving the white SUV. She sent me this email last week, threatening to put a lien on my property if I do not give her access." Martinez read the email slowly, then looked at the property deed and county map I had included. He leaned back in his seat, exhaling through his nose. "Okay," he said. "This is not just trespassing. This is someone trying to intimidate you into giving up legal rights. That changes things." He asked if I had any objection to him contacting the HOA directly. I said no. He made a note in his report, then looked at me. "Here is what I recommend," he said. "File a formal complaint. I will open an investigation and reach out to Miss Harcourt. If she continues to trespass after being notified by law enforcement, that is going to escalate the charges. In the meantime, keep your cameras running and document everything. Do not engage with her directly. Let me handle it." I nodded. He handed me a business card with his direct number and told me to call if anything else happened. Then he drove off, leaving me standing at the gate, watching the dust settle on the road. 2 days later, I received an email. It was not from Fiona Harcourt. It was from the Meadowbrook HOA secretary, a woman whose name I did not recognize. The email was brief and formal. It stated that the HOA board was holding a special meeting on Friday evening at 6 p.m. to address community concerns regarding property access and boundary disputes. The meeting was open to all residents and affected parties. I was invited to attend. The email did not mention my name, but it was clear who the affected party was. I read the email 3 times, trying to decide if this was a trap or an opportunity. Then I replied, "I will be there." Friday came faster than I expected. I spent the afternoon going over my notes, printing extra copies of the county documents, and making sure I had everything organized. I did not know what to expect from this meeting, but I knew I needed to be prepared. At 5:30 p.m., I got in my truck and drove to the Meadowbrook Community Center, a low building near the entrance of the subdivision, with large windows and a parking lot that was already half full. Inside, the meeting room was set up with rows of folding chairs facing a long table at the front. There were about 40 people scattered throughout the room, most of them residents I did not recognize. Some were talking quietly among themselves, others were looking at their phones. At the front table sat 4 people, 3 men and 1 woman. Fiona Harcourt was in the center, wearing the same blazer I had seen before, her hair pulled back, her expression composed. She looked exactly like someone who was used to running meetings, used to being in control. She did not look at me when I walked in, but I knew she had seen me. I took a seat near the back and waited. At 6 p.m., Fiona stood and called the meeting to order. She introduced herself and the other board members, then launched into a prepared statement. She explained that the HOA had been working to improve traffic flow and safety within the community. She said that a private landowner adjacent to Meadowbrook had been blocking a route that residents had been using for months, creating inconvenience and potential safety hazards. She did not say my name, but everyone in the room knew who she was talking about. She described the route as a community access road and claimed that the HOA had historical precedent for its use. She said the board was exploring legal options to formalize the easement. I sat there, listening, feeling my jaw tighten with every word. She was lying, not stretching the truth, not spinning the facts. Lying. There was no historical precedent. There was no community access road. There was just my land, which she had decided to drive across because it was convenient. And now she was standing in front of 40 people, telling them that I was the problem. When she finished, she opened the floor for questions. A man in the 3rd row raised his hand. He asked how long the access route had been in use. Fiona answered smoothly. "Several months," she said. "Since the spring." Another woman asked if the landowner had been consulted. Fiona hesitated, just for a second, then said, "We have reached out multiple times, but the landowner has been uncooperative." I felt my hands curl into fists on my lap. That was my cue. I stood up. Fiona's eyes snapped to me, and for a moment, the room went quiet. I kept my voice calm. "I would like to clarify a few facts," I said. "My name is Alden Pierce. I own the property Miss Harcourt is referring to, and I would like to address some inaccuracies in what was just said." Fiona's expression tightened, but she gestured toward me with one hand. "Please," she said, her tone icy. "Go ahead." I walked to the front of the room and pulled a folder from under my arm. I opened it and held up the county parcel map, turning it so everyone could see. "This is the official county map," I said. "My property is parcel 47B. It sits on the north side of the county road. Meadowbrook is entirely on the south side. There is no overlap. My land is not part of this HOA. It never has been." A few people leaned forward, squinting at the map. I continued. "I purchased this property in 2018, 2 years before Meadowbrook was developed. I have the deed right here, recorded with the county. There is no easement. There is no historical access. There is just private property that people have been driving across without permission." Fiona interrupted. "Mr. Pierce," she said, "the board has reviewed the boundaries and we believe there is shared access." I turned to her. "Based on what I said?" She blinked. "Based on community planning documents," she said. I shook my head. "Show me," I said. "Show me one document that says my land is part of your HOA. One survey, one plat, one recorded easement." She opened her mouth, then closed it. She looked at the other board members. One of them, a man in a polo shirt, leaned over and whispered something to her. She shook her head slightly, then looked back at me. "We will provide that documentation in due course," she said. I pulled out the printed email she had sent me and held it up. "This is an email from Miss Harcourt," I said, "threatening to place a lien on my property if I do not give her access. I have video evidence of her vehicle trespassing on my land at least 7 times in the past 2 weeks. I have filed a formal complaint with the county sheriff's office, and they are currently investigating." I paused, letting that sink in. "This is not about community access," I said. This is about someone deciding that rules do not apply to them. The room was silent. Fiona's face had gone pale. Then she stood abruptly. "This meeting is not the place for personal accusations," she said, her voice rising. "You are disrupting a legitimate board discussion." I did not raise my voice. "I am clarifying facts," I said. "You invited me here. I am just making sure everyone knows the truth." One of the residents, a woman in the front row, raised her hand. "Wait," she said, looking at Fiona. "His land is not even in our HOA. Why are we discussing this?" Another man spoke up. "Yeah, I thought we were talking about an internal road." Fiona held up one hand, trying to regain control. "Please," she said, "let's stay focused." But the murmurs had already started. People were talking to each other, pulling out their phones, looking confused. Fiona's carefully constructed narrative was unraveling in real time. She looked at me, her jaw tight, her hands gripping the edge of the table. "You will be hearing from our attorney," she said. I nodded. "I look forward to it," I said. Then I turned and walked out of the room, leaving the folder of documents on the table behind me. As I pushed through the doors into the cool evening air, I could still hear the voices inside, louder now, questioning, demanding answers. I got in my truck and drove home, feeling lighter than I had in weeks. The fallout came fast. By Saturday morning, my phone started ringing. The first call was from Deputy Martinez. He told me that he had been contacted by 3 different Meadowbrook residents who attended the meeting, all of them asking questions about the HOA's claims. He said the investigation was moving forward and that he planned to interview Fiona Harcourt within the next few days. He also mentioned that the county attorney's office had been copied on his report, given the threat of a fraudulent lien. I thanked him and hung up, feeling a flicker of satisfaction. The system was working. Slowly, but it was working. The second call was from a reporter at the local newspaper. She said she had heard about the HOA dispute and wanted to know if I was willing to talk on the record. I hesitated. I did not want this to turn into a media circus, but I also knew that sunlight was the best disinfectant. If people in the county knew what Meadowbrook was trying to do, it would be harder for Fiona to keep spinning her version of events. I agreed to a brief interview. She asked me to summarize what had happened. I kept it simple. I told her about the repeated trespassing, the threatening letters, and the false claims of jurisdiction. I told her I had county records and video evidence to back everything up. She asked if the HOA had responded. I said they had threatened legal action, but had not provided any documentation to support their claims. She thanked me and said the story would run early next week. On Sunday, the cameras caught something new. It was not the white SUV this time. It was a silver sedan, the same one that had come through hesitantly a week earlier. But this time, the driver did not cut across the field. The car slowed at my gate, paused for a long moment, then turned around and drove back toward Meadowbrook. I watched the footage twice, trying to read into it. Maybe word was spreading. Maybe people were starting to realize that the so-called access road was not legitimate, or maybe they were just afraid of getting caught on camera. Either way, it was progress. Monday afternoon, Deputy Martinez called again. He had interviewed Fiona Harcourt. He said the conversation had not gone well. She had insisted that her understanding was that the land had always been part of the community planning area, but when pressed for documentation, she could not produce anything. She had become defensive, claimed that the county records were outdated, and suggested that Martinez was not doing his job properly. He said she had refused to admit to trespassing, even when confronted with video evidence. But here is the thing. Martinez said, "She admitted to me that she drove across your property. She tried to frame it as using a public route, but she admitted it. That is enough for me to move forward." He told me he was filing formal charges, criminal trespass and criminal mischief, both misdemeanors, but enough to put her on record. He said the case would go to the county prosecutor, who would decide whether to pursue it in court or offer a plea deal. He also said that he had forwarded the email threats to the county attorney's office, and they were reviewing whether Fiona's attempt to file a lien constituted fraud or abuse of process. I asked what that meant. He said if the county attorney found that she had knowingly made false claims to intimidate me, she could face additional civil penalties, including fines and an injunction preventing her from making further threats. I thanked him. He told me to keep documenting everything and to let him know if anything else happened. That same evening, I received an email from the Meadowbrook HOA. It was not from Fiona this time. It was from the vice president, a man named Thomas Chen. The tone was completely different. The email began with an apology. On behalf of the board, Mr. Chen wrote, "I want to extend our sincerest apologies for any inconvenience or distress caused by recent events. It has come to our attention that there were significant misunderstandings regarding property boundaries and access rights. We have reviewed the county records and confirmed that your property, Parcel 47B, is not within the jurisdiction of the Meadowbrook Homeowners Association. We regret any confusion and any actions taken based on incorrect information." The email went on to say that the board had voted to remove the access route from all community maps and signage. It stated that residents had been notified that the route was private property and was not to be used. It also mentioned that Fiona Harcourt had stepped down from her position as president, effective immediately, to allow the board to move forward constructively. The email ended with an offer. "If there is anything we can do to repair the relationship between the HOA and you, please do not hesitate to reach out. We value good neighborly relations and hope to resolve this matter amicably." I read the email 3 times. Part of me wanted to feel vindicated, and I did. But another part of me felt exhausted. This whole situation could have been avoided if Fiona had just respected a simple boundary. If she had checked the county records before making threats. If she had cared about the truth instead of just getting her way. But she had not. And now she was facing criminal charges, public embarrassment, and the loss of her position. I did not take any pleasure in that. I just wanted it to be over. 2 weeks later, I received a letter from the county prosecutor's office. It informed me that Fiona Harcourt had accepted a plea agreement. She pled guilty to 1 count of criminal trespass and 1 count of criminal mischief. She was ordered to pay a fine of $500, reimbursement for damages to my property for $320 based on my documented repair costs, and was placed on 6 months of unsupervised probation. The letter also noted that she had been issued a formal warning regarding the fraudulent lien threat, and that any further attempts to interfere with my property rights would result in additional charges. The case was closed. I sat at my kitchen table, holding the letter, feeling a strange mix of relief and anticlimax. It was over. Officially. Legally, Fiona Harcourt had been held accountable. The HOA had corrected its maps. The county had confirmed my property rights. Everything I had worked toward for the past 2 months had come to fruition, but it did not feel like a victory. It felt like the end of something that should never have started in the first place. A few days later, the local newspaper ran the story. The headline read, "President resigns after trespassing dispute." The article summarized the situation, included quotes from my interview, and noted the criminal charges and plea deal. It also mentioned that the Meadowbrook HOA had issued a public apology and updated its records. The article was fair, factual, and oddly satisfying to read, not because it made me look good, but because it laid out the truth in black and white. Property rights matter. Documentation matters. And no one, no matter how confident or powerful they seem, is above the law. On a Friday afternoon in late summer, I was standing at my new gate, checking the solar panel on the automatic opener, when a car pulled up on the county road. It was a small sedan, and the driver rolled down the window. It was a man I recognized from the HOA meeting, one of the residents who had asked questions after my presentation. He waved. "Hey," he said. "I just wanted to say, I'm sorry about all that. A lot of us had no idea what was going on. We thought it was just an HOA road issue. I did not realize she was driving through private land." I nodded. "I appreciate that," I said. He looked at the gate, then back at me. "For what it is worth. She does not speak for all of us. Most people around here just want to live quietly and not cause problems." I believed him. "Thanks for stopping by," I said. He nodded and drove off. That night, I walked the property one last time before the sun set. The wheat had mostly recovered. The fence posts were repaired. The new gate stood solid and unmoving, a line that would not be crossed again. I thought about everything that had happened. The anger, the frustration, the hours spent documenting and researching and preparing. It had been exhausting. But it had also taught me something. Boundaries are not just physical. They are moral. And defending them is not about being difficult or uncooperative. It is about standing up for what is right, even when it is hard, even when it costs you time and energy and peace of mind. I stood there as the sky turned orange and pink, feeling the weight of the past few months lift off my shoulders. It was over, and I had won. Not because I had destroyed anyone, but because I had defended what was mine. That was enough. Fall came quietly. The wheat I had planted in the spring was harvested in late September. Golden stalks bundled and stored in the barn behind the house. The field lay fallow now, resting under a sky that had turned from summer blue to the pale gray of approaching winter. The air smelled different, cooler, sharper, like the land was taking a breath before the cold set in. I spent my mornings the same way I always had, walking the property with coffee in hand, checking the fence line, feeding the chickens, and making sure everything was in order. But now, when I reached the gate, I did not feel that old knot of tension in my chest. I just felt peace. The steel gate had become part of the landscape. It no longer looked new or out of place. The metal had started to weather slightly, a thin patina forming on the surface, and the solar panel on the opener was dusted with pollen and dirt. The cameras were still there, still recording, but I had stopped checking the footage every day. There had not been a single violation since the plea deal. Not one car, not one tire track, not even a hesitant approach. The route that Fiona Harcourt had tried to claim as community access had been erased from Meadowbrook's maps, and the residents had found other ways to get where they needed to go. The shortcut was gone. The boundary was respected. One Saturday morning in early October, I was repairing a section of the chicken coop when I heard a car pull up near the gate. I straightened, wiping my hands on my jeans, and walked over. It was a pickup truck I did not recognize. Newer, dark blue, with a Meadowbrook HOA parking sticker on the windshield. The driver was a woman in her 60s, gray hair pulled back in a bun, wearing a fleece jacket and gardening gloves. She rolled down her window and smiled. "Mr. Pierce," she said. "I am Claire Donovan. I live over on Maple Drive in Meadowbrook. I hope I am not bothering you." I walked closer. "Not at all," I said. "What can I do for you?" She reached into the passenger seat and pulled out a small basket covered with a checkered cloth. "I wanted to bring this by," she said. "It is just some apples from my tree and a loaf of banana bread. I know things got ugly with the HOA earlier this year, and I wanted you to know that not everyone felt the way Fiona did. A lot of us were horrified when we found out what she had been doing." I took the basket, surprised. "Thank you," I said. "That is very kind." She nodded. "I also wanted to say that the neighborhood appreciates you standing your ground." It sent a message. We had a board election last month, and a lot of people voted for candidates who promised transparency and accountability. I think what happened with you was a wake-up call. I did not know what to say to that, so I just nodded. "I appreciate you stopping by," I said. She smiled again. "You have a beautiful piece of land here," she said. "I can see why you wanted to protect it." Then she waved and drove off, leaving me standing there with a basket of apples and a strange sense of closure I had not expected. That afternoon, I sat on the porch and ate a slice of the banana bread. It was good, sweet and dense, the kind of thing someone had put time and care into making. I thought about Claire's words, a wake-up call. I had not set out to change anything beyond my own property line. I had just wanted people to stop driving through my land. But in defending that line, I had forced a system to confront its own overreach. I had made people ask questions. Who has authority here? Who decides what is fair? What happens when someone in power stops following the rules? Those were not small questions. And the fact that people in Meadowbrook were asking them now felt like something worth the fight. The county had updated their records too. A few weeks after the plea deal, I received a letter from the county planning office. It included a new printed map with my parcel clearly marked and labeled in a way that left no room for confusion. Private agricultural land, no public access, no easements. The letter thanked me for bringing the boundary issue to their attention and noted that the discrepancy had been corrected in the official database. It was a small thing, bureaucratic and procedural, but it mattered. It meant that if anyone else ever tried to claim my land was part of something, it was not. The county would have a clear record to point to. The truth was now part of the system. I had also started hearing from other people in the area, not just Meadowbrook residents, but landowners from neighboring properties who had dealt with similar issues. One man called to tell me about an HOA in the next county that had tried to force him to remove a fence on his own land. Another woman emailed to say she had been threatened with fines for refusing to join an association she had never agreed to be part of. They all had the same question: how did you fight it? What did you do? I told them the same thing every time. Document everything. Know your property lines. Know the law. Do not assume the other side is telling the truth just because they sound confident. And do not be afraid to stand up for yourself, even when it feels like you are alone, because you are not alone. The law is on your side. You just have to be willing to use it. By late October, the leaves on the trees along the county road had turned gold and red, and the mornings were cold enough that I could see my breath when I stepped outside. I spent a weekend reinforcing the barn, replacing old boards and patching holes in the roof before the snow came. It was good work, the kind that made my muscles ache satisfyingly. On Sunday evening, I stood at the gate one last time before heading inside. The sun was setting behind the field, casting long shadows across the land. The gate was closed, the lock engaged, the cameras quietly recording, the sign next to it: private property, no trespassing, violators will be prosecuted, was clean and legible, untouched and unquestioned. I thought back to the morning when the white SUV had first torn through my field, the morning when I had stood at the old wooden gate and felt that first cold flicker of violation. That gate was gone now, replaced by something stronger, something that could not be knocked down or ignored. But the real change was not the gate. It was me. I had learned that boundaries are not just about keeping people out. They are about knowing what you will and will not tolerate. They are about having the courage to say no, to stand firm, to demand respect, even when no one wants to give it. And they are about understanding that sometimes the only way to protect what matters is to fight for it, not with fists or anger, but with facts and patience and an unshakable belief that you are right. I opened the gate with the remote, walked through, and let it close behind me with a soft metallic click. The sound was final, certain, like the last word in a conversation that had gone on too long. I walked back to the house, the sky darkening above me, and felt the kind of tired that comes after a long journey. It was over. The land was still mine. The boundary was still intact. And for the first time in months, I could look at that gate and feel nothing but calm. That was all I had ever wanted. And now, finally, it was mine to keep. Standing up for what is right is never easy, but it is always worth it. If this story resonated with you, if you have ever had to defend your own boundaries or fight against someone who thought the rules did not apply to them, I want to hear from you. Drop a comment below and tell me your story. And if you believe that respect, accountability, and justice still matter, subscribe to Karma Fence, because every boundary we defend makes the next one a little easier to protect. Let's stand together.